Whoo, child. Okay, they should be back soon. I know they told the jury to be back at 12:15. Good afternoon. Hopefully everybody enjoyed their lunch. I should have ordered some lunch, but I didn't. But I'm getting ready to. I'm getting ready to order me a salad. Okay, there they go. I know they told the jury to be back at 12:15. I'm sorry, at 1:15 their time. So, woof. Heaven help me. I got me some popcorn. Ooh, let me grab me a Pepsi and I'm be ready.
So back on the record, we reconvene outside the hearing in presence of the jury with counsel and Mr. Apodaca present. A couple housekeeping things. I need jury instructions.
And Your Honor, I'm just putting some finishing touches on those right now.
Okay. I need the states now. I'll need the defenses if there's any proposed additions or changes when we get there. Mr. Nair.
Yeah, we have, my office is preparing, we're preparing the Lewis instructions and second degree involvement, but Ms. Murphy said that she has the second. She's going to oppose voluntary manslaughter. We are going to propose a voluntary manslaughter.
Okay, well, yeah, we'll see. We'll have those arguments when we get there.
Okay.
Before we broke, we were having a bench conference. Anything else on that issue?
And no, Judge, on further discussion, co-counsel, we're just gonna let it go.
Okay. Any other issues for the state before we have the jury back in the room?
Yes, Your Honor. Before the lunch break, you may have overheard my conversation with Mr. Nair. When we printed 89A yesterday, which was the Celebrite extraction report from the defendant's phone, the one that contained the actual messages and search terms. When it printed yesterday, there was a printer malfunction and it left off pages 18 through 24. These were included on the exhibit when it was published to the jury off of the disc. It is not one of the, that we then substituted it in as 89A in hard copy form because we needed to make an additional redaction that we caught. This isn't part of the redacted portion, but it is the remainder of the document as previously admitted and published to the jury. I would just ask that we be able to attach pages 18 through 24 to 89A before it gets sent back. As I said, it was part of the original document moved into evidence.
Mr. Nair?
You don't object, yeah.
Okay. So how many pages total are now in A?
89A will be 24 pages once I add these remaining 6.
Okay. Go ahead.
And Judge, this exhibit, the jury question?
Yes, we just need to hang on to it. You just give it to the.
Just to confirm for purposes of the record, the last page in the document when it was placed up here is page 17, and the remainder that I'm attaching is 18 through 24. Do I save those?
Yep, too many staplers. Anything else for the state?
Nothing from the state, Judge.
For the defense?
Not for defense, Your Honor, thank you.
Continue with Cross. Let's go ahead and bring her in. And is the jury back yet? And have you come back around and take your seat?
All right, Sid, let's go. Let's go. Oh, one time. Oh, never. Oh, so they're not charged. Okay. Uh-oh. 62% on the battery. Okay. That's why the remote. Oh. Oh, guys, cutting all the TVs back on. Okay. All right, guys, how was lunch? How was lunch? Ooh, 11 out of 12 items shopped. I got my Instacart order in, though. Instacart is in. Denver has cookies. That drove me crazy. I got a popcorn, some Pepsi. Oh, they showing what we watching. Okay. And what's I doing over here? Okay, is the dress code for Saturday's retreat casual? That's a good question. What is the dress code? Please tell me. Evaluation. All right, guys. Oh, wrong one. Wrong form. All right. Boom. So all of this needs to go over there. This. Oh, oh, you got homecoming? Oh, my God. You still look crazy. Getting him. What do we think she's thinking about? Getting his ass. To be quite honest. She got to be feeling crazy. Every time she has to say something about this case, she got to be feeling real stupid. Oop, hold on. Yeah, she's got to be feeling beyond crazy. Because everything he had her believing in was just a mess he was making up. That he didn't even participate in. I mean, I'm glad he didn't. That would just take people out of the world at the hands of a crazy person. But so thank God he wasn't as bold, but he had her manipulated so bad that she thought that he was, that she went and tried to join the damn ghost crew. Only to find out, ain't there? I mean, I don't know what she thought was going to happen after she joined the ghost crew anyway, besides jail, but
All right.
You want it to belong. Careful what you wish for. Oh.
May be seated in the courtroom. We continue with cross-examination.
Yes, Your Honor. All right. Good afternoon, Kara. You have stated that you have a crazy side that comes out when you're drunk, correct?
Yeah,
Okay. And you stated that you would call this personality Abby?
Isaac started calling her that, so I started calling her that.
Okay. And you also stated that you have several different personalities, correct? Yes or no?
I do not have several personalities. I thought I did at
Okay.
the time, but
I
I do
just
not
said
now.
yes or no, but you believed previously that you had several different personalities, correct?
Yes.
Okay. Now, you stated that Isaac had the dagger, correct, multiple times?
Yes.
Okay, so his hands and fingers touched the dagger according to you?
Yes.
Okay. You also stated that Isaac pushed down on the dagger with his palm, correct?
Yes.
Okay. You also stated that Isaac handed you the sword, correct?
Yes.
So Isaac picked up the sword with his hands, correct?
Yes.
So Isaac's hands and fingers were on the sword, correct?
Yes.
Okay. You testified that you saw the sword on the table, correct?
When I came back, yes.
Okay. So you didn't leave the sword on the table, correct?
No, I did not.
Grace was not moving when you left, correct?
Correct.
Okay. So someone put that sword on the table, yes or no,
Yes.
according to you? And so you believe Isaac had put that sword on the table?
Yes.
Okay. And there was only one shower in the house, correct?
Yes.
Okay. How many times did you stab Grace?
I
Damn.
don't remember how many times.
Several times?
Yes.
You stabbed her in the neck?
I was stabbing her everywhere.
Okay. You previously stated that you did not stab her in the neck?
I don't remember if I stabbed her in the neck or not.
Okay. And previously, you had stated that decapitation wounds were the result of Isaac, correct?
Yes.
And today your testimony is different, correct?
How so?
You're basically saying something completely different, that Isaac just handed the sword to you, correct?
He handed it to me, but when I left and came back.
Okay, I'm
that's-
just asking you, you're saying that Isaac handed you the sword.
Your Honor, can the witness be allowed to finish an answer that's responsive?
Come on.
Ask your question, counsel. You can address it on redirect.
Okay. Yes or no, Isaac handed the sword to you,
Yes.
correct? Okay. And then afterwards, you saw the sword on the table, correct?
On the table when I came back.
Okay. 1 second.
I said that. I said I wonder if he attempted to do something to Grace, seeing if he can get his balls up to do what she did while she was in the shower and about threw himself into a tizzy mentally. And now
You
it's
stated
not
that Isaac had kept all the money from the sex
like
work,
he was
correct?
decapitated or nearly
How
decapitated.
were you able to afford the sword?
He let me get a Amazon gift card for one.
I'm sorry?
He gave me an Amazon gift card. He rarely let me keep the money, but when he did, he would let me.
Redirect.
Briefly, Your Honor. Kiara, when opposing counsel was questioning you, they were asking you about your plea agreement. Do you remember some of that discussion? Okay. Does your plea agreement require you to help get a conviction for Isaac Apodaca?
No,
What is your number one job as a result of your plea agreement?
to testify honestly.
I want to clarify the alcohol that you consumed, okay? As you sit here today, how much alcohol did you consume during the night of October 28th into the 29th of 2022?
I honestly don't remember very well how much there was.
By the time that you murdered Grace in the mid-afternoon, were you sober?
I was mostly sober, yes.
Did you murder Grace Jennings on purpose?
I believed I was doing it for a reason.
Moment, Your Honor.
Yes.
And that reason or reasons you had for killing Grace that you believed in were what?
That she deserved it because she was part of the individuals that were considered bad people for Ghost. And then a little bit more of encouragement, you could say, was the rape from when I was with her.
Nothing further, Your Honor. We'll reserve this witness out of an abundance of caution.
Okay. You're being reserved, which means you may be recalled later in the trial. The attorneys will stay in touch with you to let you know if you're going to be brought back in to testify. Okay. Ladies and gentlemen, I need to take a quick recess of probably 5 minutes. I'd ask you to go with the bailiff quickly, and then we'll bring you right back in. But all right.
They don't want them to see her leave.
You may be seated in the courtroom. She may be transported. Who's the state's next witness?
It will be Dr. Michael Wellner, Your Honor.
Okay. If you'll have him, if he's not already here, have him come into the courtroom.
Mr. Long will retrieve him.
Okay. We'll be off the record for just a minute, and we'll bring the jury back.
All right, what do y'all think about Sid? One thing I think it says a lot that her her plea agreement is not contingent upon a conviction. Because a lot of times we'll hear that and that makes you kind of think like, you'll say anything because you need this to go a certain way. She doesn't need it to go a certain way in order for her to keep her plea agreement. $15.5 is crazy. If laughing triggers her, Hannah, I'm gonna say, yeah, no. Mm-mm. All right, Instacart is on the way. Yeah, they might need to make her a little area, a little apartment in Happy Acres somewhere. I love Instacart. Listen. There are certain things I take as an answered prayer. Instacart, the Walmart app, DoorDash, that's definitely one of them. Okay. Oh, excuse me. Especially since when I became a mommy, one of my prayers was to, I prayed that I did not fumble things that my mom didn't have access to. And that's one of the things I absolutely loathed was when my mom went grocery shopping, because she would go to Kroger's, she would go to Aldi's, and she would go to the meat market. And she would be gone all day. And she had a Geostorm, so she'd fill up the whole back of the car and the trunk, and then have to drop off some groceries, then go back out and drop off some groceries, and go back out and drop off some groceries, right? By the time she got home, she was evil. She was cranky. She was tired. Then she still had to separate all that meat and bag it up and put it in the freezer, get everything labeled. She was evil. And we probably was going to have to eat Donato's pizza or something. That would be the one silver lining out of that cloud, is that she would probably order pizza. She didn't even go to Sam's back then. Now I do go to Sam's. But with that, like, the whole day was gone. She was evil. And the next day, she really didn't even really want to be bothered. She didn't want to go anywhere the next day. So if it was the weekend and you wanted to go somewhere over somebody's house or something, she probably didn't feel like going. And so that's one of the things that I do not take for granted, is that I don't have to spend a day away from being with the boys or being upset, or they can drop off my groceries. I'll still cook. Like, my mood or my day is not altered because of. So that's one thing my mom did not have access to that I do. Also, we still got the same banner up. So I'll have one person at Aldi's, another person going at Fry's. I'll have the Walmart app going, and we just got to put them up. I don't have to leave. I don't have to do one thing I do hate doing, and I'm not going to lie to you guys. The one thing I used to always hate doing is having to stop after work. So that was another thing. Hey, oh, I didn't even see you in the camera. Nothing. They getting ready to Instacart should be here in a second. So just leave out that. Would you get the lamb or the bison?
Bison. The bison.
You
Oh.
said you wanted bison.
I was asking you which one you wanted.
Bison?
Okay, well, they should be pulling up in a few.
What you doing?
They said, hey, babe. You said, hey, running down the hallway. Mm. Some lamb taco. Oh, hey, babe. Desi said, here in the on YouTube, Desi said she just had lamb tacos. I said Desi in the chat just said they just had lamb tacos. We ain't tried that. We haven't tried that. I got a new iced coffee order today and lamb tacos. Okay. Okay, 2 for 2. Take care of me.
Lamb and bison, anything is all right. Especially if you know how to season
He does watch trials, kind of. Oh.
Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth, and the penalty of perjury?
You can't say eye catching. He watched the whole
And a
dirt
reminder to
trial.
everyone in the gallery to turn off your electronic devices.
that wasn't a good watch.
If you'd begin by introducing yourself to the jury by stating your name and spelling it for our record, please.
Yes.
I ain't gonna say praying.
My
Just,
electronic
man, I was
device.
thinking the wrong thing
Thank you.
before I happened. Give me a clue, though. I watched the YSL trial too. That was interesting.
You didn't watch all of it.
I had to go back, but I ended up watching
My
that.
name is Dr. Michael Wellner, Welner.
Ms. Murphy.
Thank you, Judge. Good afternoon, sir.
Good afternoon.
What do you do for a living?
I'm a psychiatrist and forensic psychiatrist.
Let's talk about your educational background that led to you being a forensic psychiatrist. I assume you graduated high school.
You about to die.
Yes.
Okay, buddy.
After high school, what did you do?
I went to the University of Miami in Coral Gables and was a biology and chemistry major. And from there, I went to medical school at the University of Miami in Florida and finished my medical degree in 1988. And from there, I went to New York City and I did a rotating internship between 88 and 89 in psychiatry, emergency medicine, and internal medicine. And then I completed a residency in psychiatry at Beth Israel Medical Center in 1992. I also completed fellowship training at the University of Pennsylvania in forensic psychiatry in 1992 as well. And then I entered practice.
What is the field of psychiatry?
Psychiatry is the study of the mind and emotions and behavior.
What's forensic psychiatry?
Forensic psychiatry is where those aspects of behavior and emotions and personality intersect with different legal questions. Sometimes they're criminal legal questions, sometimes they're in courts that are unrelated to criminal law.
Are you board certified?
I am.
In what fields or field?
I'm board certified in psychiatry and I'm board certified in forensic psychiatry.
And how long have you been certified in those fields?
I've been certified since the early 1990s when I started my career in psychiatry. I board certified in 1996 and I recertified most recently in 2016.
After completing your fellowship, where did your professional experience proceed?
I began a practice of treating patients as a psychiatrist and a psychopharmacologist
I'm sorry, what's a psychopharmacologist?
Psychopharmacology is the treatment of clinical conditions with psychiatric-related medications, like antidepressants, anti-anxiety medicines, antipsychotics. And I had a full-time position as what they call an attending physician, where you treat patients and you provide psychiatry services at Bellevue Hospital in New York City on the correction psychiatry unit.
And you had direct patient care responsibilities there at Bellevue?
I did.
After your time at Bellevue Hospital and the correctional psychiatry unit, what did you do?
I entered full-time practice in 1995 and have been in full-time practice since.
You can have this.
What's the scope of your practice over the years?
I had a treatment practice from 1995 until COVID. In COVID, when people started going remote, it's not how I was trained to treat people. And so that was when I moved into forensic practice full-time. But my treatment practice involved working with patients who had repeatedly violent behavior, people who didn't respond to other psychiatrists' care. And so I was referred patients by other psychiatrists who had particularly complex conditions. And then the other part of my practice was forensic evaluation and forensic consultation in various cases.
Sure. In terms of the variety of those cases, what types of cases have you consulted on or personally treated or participated in?
My treatment practice was very different from my forensic practice, but my forensic practice has been very much involved in a variety of criminal court cases, cases that relate in a non-criminal perspective. I guess I'll break down the criminal in a moment, but in a non-criminal context, employment-related context of people having experiences with hostile work environment and emotional experiences and distress as a result. In securities law relating to investment, competency to invest, competency to make transactions, competency to draft a will, as well as the criminal cases. And in the criminal context, really across I would say the life cycle of a case, from the whodunit questions of death investigation, where it's uncertain as to whether how a person died. A person may have committed suicide, a person may have been murdered, a person may have died accidentally, may have died of natural causes. And so those are questions that implicate psychiatry in a matter what's typically referred to as a psychological autopsy. And then once a person is in custody, essentially why done it, ranging a variety of why done it questions, from pretrial questions that may relate to disputed confessions, to questions of whether someone is competent to stand trial or competent to be their own attorney, to issues of criminal responsibility of a person who may be raising the insanity defense, or who may be raising other issues where they felt that they were extremely emotionally disturbed, depending on the state, when something happened, or whether if someone was really quite intellectually limited or very impaired, whether they actually had the ability to form intent. So the law defines the nature of the case, and in different states, there are different laws that bring different cases up for consideration. And included among those are questions of battered women cases where there are female defendants and they raise battered women defenses. So there are various that relate to criminal responsibility questions. And then in a sentencing context, there are various aspects of a person's psychosocial history, of biological history, neurological history that may impact sentencing after a person may have been found guilty. So pre-sentencing considerations as well.
With respect to your private practice of forensic psychiatry, are you able to provide the jury with a rough estimate as to the number of murder cases that you've consulted on in your professional career?
I would say in over 30 years, I've consulted on over a few hundred murder cases at this point.
What is the forensic panel?
The forensic panel is a practice that I started in 1998 and have been chairman of since then. It's a multidisciplinary practice of psychiatry and the behavioral sciences, forensic pathology, forensic nursing, radiology, and other medical sciences that evaluates a range of cases involving prospective collaborative peer oversight.
What do your current practice activities consist of? What do you do?
Well, in addition to being as chairman of the forensic panel, which is really my primary activity, probably my activities involve actually working on cases, which is what brings me to here to you all today. I supervise other physicians in the course of their conducting evaluations. I conduct research, and I teach, and I write. So it depends on the month, but that's the breakdown of my practice time.
Okay. You said that you engage in research. What are you published in any areas?
I've published in a number of different areas and continue to contribute to the psychiatric and medical literature. The areas of my principal research have been, I've researched and developed a method for peer review to promote the integrity of forensic science that's applicable across forensic sciences. I've researched and optimized and published on something called the depravity standard, which is an evidence-based way for determining the most blameworthy of crimes for application in the criminal court. I've also researched disputed confessions and published on that. I've researched mass and spectacle homicide. I've researched and published on drug-facilitated sex assault. I have researched on cult leaders and their vectors of influence, as well as the assessment of homicide and the maturity of those young people who commit homicide, as well as fetal abduction.
Okay. Wow. Thank you. That is a broad range. Let's talk about a few other things. What is the New York Supreme Court's highly qualified independent psychiatrists list or panel?
The New York State Supreme Court maintains a list of individuals who it deems has the qualification to work on certain cases within the New York court system where an independent psychiatrist that has no, that's not brought in by a prosecutor, not brought in by defense attorneys, but a question may come up, a psychiatric legal question may come up. The court wants to be informed by it. So they maintain a list of people that they may reach out to and involve in those particular cases.
Do you have any association to the Mount Sinai School of Medicine?
Yes,
What is that?
I'm a clinical professor of psychiatry at Mount Sinai School of Medicine.
Can you explain the difference between clinical psychiatry and forensic psychiatry?
Clinical is a treatment context. So clinical is the psychiatrist that you see for a given condition, and a psychiatrist hears things and is supposed to be hearing things exactly as you would say them to be. So if you were to come to me and give me a variety of symptoms relating to anxiety, I would take what you have to say at face value because you're coming to a psychiatrist to get well. In the forensic context, and so you operate under the presumption of trust, you know, and everything you're hearing is everything as it is. And the forensic role, you operate under the presumption of caution because someone's a litigant, they're involved in a case. And so they're hearing things the way they want you to hear them because you may one day be in court and be asked to give testimony. So by virtue of that, you're relying upon evidence and you're relying upon other sources that can give you a sense of confidence that what you're hearing is exactly as it is. And those kinds of responsibilities and challenges don't exist in the clinical world. It's much more linear. I don't feel well, just as it is when you see any doctor. I don't feel well, I'm coming to you to get me well. Please get me well. End of story.
So when you're operating in the forensic psychiatric realm, what types, just kind of broad categories of corroborative evidence might you review or rely on?
Well, it depends on the question that's being asked. So if it's a question of competency, if there's a question of competency to stand trial, well, we're in mid-July. And so I would rely upon information that would inform someone's mental state in the middle of July. person may have a history of psychiatric problems or may not have a history of psychiatric problems. They may have changed. There may be certain circumstances that impact that individual's competency. So I would be looking at a range of objective information, sometimes subjective, but objective information, whatever one can gather, either from documents or sources who are witnesses, who've observed things, that can help to converge all of that data, give me some sense of confidence that I have the ability to address those particular questions. Can a person maintain his behavior in court? Does he have a sense of reality? Can he conduct his emotions properly? Are his thoughts organized? Is he rational right in the here and now to participate in this court proceeding? But that may be totally different from the nature of the demands that I might have in a disputed confession case, in which case I would be focusing on.
And let me just stop you for a
Sorry.
moment. It's okay, Dr. Wilner. Let me just stop you for a moment and ask more specifically, in cases where you may be asked to answer questions related to interpersonal relationships, or in a murder case, or a case that is in a criminal trial that you may be consulting on, just what broad categories generally would you rely on for evidence for your review?
Well, in those kinds of questions, you really want to know the best way to boil them down is to appreciate them is what was the person's mental state at the time of the offense. So you're looking at that moment in time, or right before it and right afterward. So any kind of documentary evidence, any evidence of the person's function, any evidence of the person's communication, how they were relating and what they were saying, the kind of data that one can extract from a smartphone or one can extract from a phone, or sometimes digital evidence that shows a person's movements or transactions or decision-making or communications. So anything that informs a person's function and a person's decisions around the time of the offense,
Thursday.
and how that may answer the psychiatric questions in particular that are posed.
That was smooth in the
You've obviously been called during the state's case. Do you exclusively consult with prosecution, or have you consulted with defense in cases as well?
I consult to both prosecution and defense.
Okay. Have you ever testified as a witness on behalf of the defense in cases?
I have testified as a witness on behalf of the defense.
All right, we get it. You ain't biased. Let's go.
Have you ever consulted on cases involving a perpetrator or alleged perpetrators who are intimate partners themselves?
I have.
Of course, he did to even work with cult
How many
leaders.
times have you testified as an expert witness?
Oh, come on, y'all gonna irritate
Well,
me. I need to eat.
I probably testify about twice a year. The most of the cases that I consult on never get to court. And I believe this is the only case that I've testified on this entire year. So you multiply that by 30 odd. I think earlier in my career, I probably testified a little bit more frequently. So I would say probably in the neighborhood of 100 times at this point.
Have you ever been qualified in the realm of psychiatry?
I have.
Have you ever been qualified in the realm of forensic psychiatry?
I have.
Have you ever not been qualified when tendered as an expert in psychiatry or forensic psychiatry?
I have not.
All right. In the course of your professional activities, have you ever consulted on cases where allegations of domestic violence were included in the history?
Yes.
Have you followed, or do you maintain or stay up on the research that has surfaced regarding interpersonal violence and its relation to complex crimes?
Yes.
Your Honor, at this time, I tender Dr. Wellner as an expert in psychiatry and forensic psychiatry.
Any objection?
No further objection, Judge.
Dr. Weinler is
Thank you.
admitted in those two areas and allowed to express his opinion in those limited areas. Ms. Murphy.
Thank you. Let's turn to this case. Very generally, what general questions have you consulted on to try and answer in this case?
I was asked to offer an opinion on the dynamics between Kira McCulley and Isaac Apodaca. I was asked to offer input about the forensic behavioral science constructs and areas of study that were illustrated in the records of their relationship. And I was asked to offer an opinion about the qualities that are documented about Kiera and Isaac that would have expressed themselves in this event that we're here about today.
Consulting on this case, I won't ask you to bullet point each individual document, but what categories of evidence did you review?
I reviewed the criminal complaint. I reviewed the police investigative reports. I reviewed the 911 call of Linda Montoya, the 911 call of Isaac Apodaca.
Disassociated
I reviewed the
identity.
approximately 15 hours of Facebook messaging between Isaac Apodaca and Kiera McCulley. I reviewed the body-worn camera by police officers when they encountered and interacted with Isaac Apodaca in arrest and also in the transport. I reviewed the autopsy report, the autopsy photographs, crime scene photographs. I reviewed Grace Jennings' social media data that was available. I reviewed Isaac Apodaca's Facebook information that was available. I reviewed Isaac Apodaca's criminal history.
Your Honor, let me just stop you there. And when you say that, you mean as it relates to the charges in this case specifically, is that correct?
Well, I didn't know that it did relate, but I reviewed it because you don't know whether it relates unless you actually
Right,
review the history.
fool.
That's how you know whether things
Oh, he didn't
are
say it.
or are not relevant.
So you
Your Honor, can we approach?
Come on up.
You already know. She tried to cover it. She tried to stop it. Too late. Nah, they calling for a mistrial. I know they are. Just talk to you down. You did all this testifying since the 80s, 90s. You know you can't say that these people got all this mess going on. You can't say Isaac a criminal, although I did wonder about that. So thank you for satisfying my curiosity, good doctor, even though you talk too damn much. Thank you for that, because
And just to clarify, when you just mentioned the words criminal history, you meant that as it related to the April 2022 incident and then this case as well.
That's correct.
All right, thank you.
okay.
Did you?
I haven't finished my answer.
Yes, let me just
you
get
don't-
there.
Sorry.
I'll ask a couple just more pointed questions. Did you review the actual phone extractions in this case?
Yes,
And did you review some recorded conversations, phone conversations?
yes, I did.
Are there any other categories of evidence that you reviewed that I've missed?
Yes, I reviewed the law enforcement interviews of Isaac Apodaca, of Kiera McCulley, of Ms. Montoya, Ms. McCulley, Ms. Montoya with, I believe, her husband, Jimmy, Roma Resendez, the interactions with Roma Resendez and Arlo, Catherine, and I believe it was Eliana. I reviewed pretrial interviews of Kiera McCulley, pretrial interviews of Ms. Montoya, and also Kiera's mother. And I conducted a number of interviews of witnesses myself. Oh, I also reviewed a psychological evaluation conducted of Kiera McCulley. And just remembering, and web searches that had been done by Isaac Apodaca around the time of the event.
Thank you. Is it customary for you to review, or for a forensic psychiatrist to review communications of people that are made close in time to an event?
Yes, it's very important to do so.
And why, generally speaking, are those communications between two people who may be involved in an event important to you?
Well, because there are various ways to explain an event. And if you have that information, then you're able to inform what happened immediately preceding an event, and you can identify any kind of triggers potentially to the event. You have an opportunity to understand how people relate, especially if they were both involved, whether there was a leader, whether there was a follower, what the nature of that is. You can gain understanding about the motive of the offenders. You can get an understanding of the victim's involvement in what transpired. So that's an example of what you can inform by the communication, and you don't know what you're going to learn until you actually study it.
What, if any, general information, and just being very general and short in your response, have you obtained regarding sex work as it relates to Kiara and Isaac?
Well, that there was an extended period during which Isaac was compelling Kiara into sex work, and that continued even after Kiara's mother found out about it and directed her to stop and directed him to stop.
Is there any research on intimate partners where one is drawn into sex work by the other?
Yes.
Okay. And is there a professional term used for that dynamic?
Yes. It's called coercive control.
How is coercive control understood in the forensic psychiatric community in terms of sex work being facilitated by an intimate partner?
Well, the person who's compelled into sex work is dependent in the relationship to the point that they lose what we call agency, and that is they really assert their choice. So that the person has essentially a loss of personal agency, and they're pulled to be responsible for the economic betterment of somebody who is otherwise able-bodied, but they're essentially supporting that individual. Within that relationship, the person doing the sex work relates to it and relates to what's going on as this is just an extension of love and intimacy. This is just something I'm doing for the relationship. And that by virtue of the dominance of the other individual, the person compelling that, and the power, and in some instances, the economic situation, in other instances, the secrecy of what's going on, and in other instances, traumatic experiences, that's what keeps that person from leaving the situation, and it maintains the situation as it is. And it's appreciated under the broader heading of domestic violence because it involves the degree of control and the expression of it that it does.
Pretty much what we know.
And without
Obviously.
going into detail, understanding well into the case, but is that history or that element of coercive control present in the case through your review of it?
I think the records and the evidence demonstrates that was present here.
And you referenced a concept of economic control. Is that a concept that you, in your opinion, have seen reflected in this case?
Sure. And if insofar as the money that Kira was earning was basically going to Isaac for his disposition and his making choices, then he essentially had economic control over the situation.
You talked about traumatic events being reflected and sometimes in the coercive control dynamic. Do you see that element present in this case, in your opinion?
Well, one instance that I know about was that she was raped in the course of doing this sex work. And that happened in October 2021.
And what concept would that lead you to consider as an element in this case?
Well, I think that it's in the context of this coercive control, it's these kinds of traumatic experiences that contribute to just the nature of the connection, the nature of the bond. I think that it's just consistent with the other aspects of the coercive control that were present within this relationship.
And so you mentioned trauma bonding as a concept. Then, what does that refer to in the context of intimate partners where one is inducing the other to participate in sex work?
Well, trauma bonding has a relationship to this in the sense that it involves a relationship between an abuser and a victim, and there's a power differential. One person has much more power within the relationship than the other. The distinctive features of trauma bonding that make it sort of its own entity is that within the relationship, the dominant individual uses positive experiences and negative experiences to reinforce control within the relationship. But the person who's more submissive and follows interprets all of the good experiences with gratitude, but interprets the bad experiences and the experiences that are reflective of abuse as something that she deserves. And they react to it as a matter of self-blame. And what distinguishes trauma bonding is that the submissive person internalizes the perspective of the dominant person as opposed to advocating her own.
So I'd like to turn for a second and talk about the relationship through your review of the records and things that you've heard in this case about the relationship between Kiara and Grace as it existed in October of 2022.
Yes.
Fair to say that you would categorize this as antagonistic?
Yes, hateful.
Hey, there you go.
In your review of this case, did you see evidence or observe information that indicated the presence of violent fantasies in this case?
Yes.
Okay, and why is that relevant to you?
Well, this ended in a murder. And so going back to the notion of mental state at the time of offense, one of the things that I have to consider is whether this is something spontaneous that just erupted and happened unexpectedly, or whether it was something that could have been otherwise anticipated.
Do the records reflect, or the things that you've reviewed reflect a understanding that Kiara was emotionally volatile?
Yes.
And let me ask you to define a term. What's gaslighting mean?
Gaslighting it's a term that actually gets a lot of use in popular communication, but it's actually also a clinical term that's attracted study within the behavioral sciences of domestic violence and intimate violence and intimate abuse. And what gaslighting on the clinical level refers to is the mental manipulation by a dominant person over an intimate partner in such a way that they question their sense of reality, and that they question a sense of whether something actually happened that did not, as a result of someone else's manipulation. That were it not for that individual, they would not have any reason to question how they think about things in their own sense of what's true or what's not true. And that the person is applying a gaslight to essentially instigate those kinds of feelings and ideas that a person would never otherwise have contemplated as true or wasn't considering.
Just started raining. In applying the term gaslighting to this case, or that, can you generally speak to some elements that you may have observed that indicate the presence of a gaslighting dynamic?
Well, I think the evidence demonstrates that that Isaac Apodaca was gaslighting Kira McCulley over the idea that she had been gang raped by Grace Jennings a number of years earlier, and that over time she came to believe it or somewhat believe it, and he reinforced it by suggesting to her that he had seen videos on the dark web and that he thought that he thought resembled her, the victim resembling her, but would reinforce this idea that Grace Jennings was responsible for having orchestrated a gang rape of her some years earlier.
You reviewed the social media messages between the Null Void and the Froggy McCullough accounts, is that correct?
I did.
Okay. And by your count, how many hours did those messages go on?
I suppose over 15 hours.
And in those communications, what did you observe Isaac Apodaca via the Null Void account do regarding Kiara and Grace?
Over the course of 15 hours, Isaac Apodaca was offering various approaches of persuasion or inducement to get Kiara to kill Grace, persistently so, relentlessly so.
Can you give some examples to the jury, please?
I'm going in an even order of sequence because she responded, she resisted, and then he would respond. Use a dull knife, it cuts like butter. She'll die instantly. I'll burn all the mess and I'll go out and buy a new bed and new blankets. You always told me, communicating to Kiara, don't be a pussy. You have to start and then I'll help. Just aim. Why are you holding back? I can't help you. I can only coach you. She's the one who sold you into sex trade. She made you feel horrible about the color of your skin and your beliefs. Just swing and don't regret your aim. I can get Christian to help. We can go to the barn. Nobody will hear her screaming because the walls are soundproofed. Those are some examples of persuasion. You wanted to kill her since 2020. What's holding you back? And others. These are some examples of the persuasions, but the inducements were, that's different. I would draw a distinction between the two.
I was just about to ask, so you mentioned the persuasions. What would the inducements to commit the murder be?
Well,
I guess, first of all, what does it mean what is an inducement?
Well, what do I get out of this? Okay. What do I get out of beyond just satisfying revenge because she gang raped me and she made me feel bad and all of these things? What do you materially offer? So what he materially offered was for her to advance in this group Ghost, that she'd be admitted and she would grow in Ghost, that she would get extra points, that she would get perks on the dark web because this was her first murder, and that she would get a rush of adrenaline from doing it. Those are ones that I can think of.
Thank you. Is there anything notable about the way that Null Void or Isaac Apodaca's account was communicating with Kiara?
Well, he clearly knew her areas of sensitivity. You know, he knew about the relationship with Grace. He knew that she was that she believed that she had been gang raped. He knew that she had violent fantasies. He knew that she wanted to join this group Ghost, and he had claimed that he had killed 40 people and that he was a vigilante and that he was killing sex traffickers and that this was her opportunity to be part of something, and knew that she wanted to be close to him and knew that she felt that she needed to be close to him, and that translated into various aspects of their relationship and her dependence, her psychological dependence otherwise. So somebody who didn't have a sensitivity to her at a deep and emotional level would not have been able to be so targeted in responding to some of her resistance, because these suggestions that he was offering were in response to her resisting or saying, I can't do this, or I give up, or I'm tired. And then he would come back and he would say something else.
You just spoke to some to evidence of resistance. Can you give, I'm not going to ask you to list everyone, but can you give some of the elements of resistance that you observed from Kiara in those messages?
Well, I can't, I mean, over 15 hours, I can't remember everyone, but again, she said, well, what about the mess? What about the mess that I'm going to, so he says, well, I'll burn the mess and I'll change the bedding and I'll buy new blankets. And so can you help? And of course he says, well, I can't help because this is a ghost thing. So I can't help. I can only coach, getting guidance about how to do it. And her saying that again, there were times that she said, I give up. I'm tired. And at one point she said, I physically can't do it and you won't do it. She said, once this happens, there's no undoing it. So these are various examples of at some point she suggested, well, why don't you grab the knife and then try to stab me and then miss? These are, there are many more within the 15 hours, but this is an example of how she would come back and then he would respond with something and then back and forth.
What is the significance to you from a forensic psychiatric perspective of Kiara asking, make me angry or make me mad, provoke me to be enraged, that those sorts of statements? Why is that?
I mean, that's, she said at some point, she said, remind me of what she's done to me. So, if the experience with Grace was that traumatic, then she wouldn't need to be reminded, especially in the context of her being persuaded to carry out this killing. So she actually asked him that, and it also reflected that she wanted to be roused to anger to bring herself to a point that she could carry out a murder.
We see in the messages at some point that Isaac seems to suggest waking Grace up and throwing her out kind of as an alternative to killing her. Do you recall that kind of line of discussion?
I experienced it as a discussion that Isaac came up with an idea of saying, you're throwing both of us out.
Operation Fake Kick Out. Do you remember those words?
Operation Fake Kick Out. And so this wasn't to as an alternative to the murder. This was in order to in some way create a conflict or a confrontation during which there'd be an encounter, because there was no confrontation the whole evening. There's no confrontation between Grace and Kiara before they went to sleep, notwithstanding the relationship. That during the evening she was there, they talked. Kiara's recollection was that she tried to make her feel better because she found out that she had just broken up with a fiance, and then she was able to feel some sense of compassion. So this was transpiring after all of that, and so she couldn't bring herself otherwise. So then they were talking about, well, exactly how could this be orchestrated? And in this context, Isaac came up with the idea of saying, just say you're kicking us both out.
And then did Kiara seemingly start to go along with the notion of a kick out?
Isaac left, and so she followed his suggestion.
What was the final message that was you reviewed in the Facebook messages?
Isaac told activity to having orchestrated the gang rape, had admitted it to him.
Is that relevant to you from a forensic psychiatric standpoint?
Well, it is, because it really was the kernel of her homicidal fantasy. That the rage that she generated toward Grace, or that she was able to maintain, because they hadn't had contact for a long time. But the nature of that rage had been cultivated through this false story of a gang rape. And that was the source. So it went right to the source of what would be the hot button of her rage.
So, Dr. Wellner, based on Kiara and Isaac's personal history, the evidence you reviewed in this case, what is your ultimate opinion on how that relationship or those relationship dynamics played a role in the murder of Grace Jennings?
Well, in various respects. First of all, he was dominant and controlling. She was very dependent. He had various homicidal fantasies, was saying that he was running a vigilante gang, had killed 40 people, and making those representations that Kiara believed. She had extreme rage towards Grace that he had cultivated in her. Isaac, who's aware of the intensity of all these feelings, brings Grace over to where they live without getting her permission, and just says she's coming over, and puts her right there in that situation. Notwithstanding that, even though she objected to it when, in the course of their correspondence, their recorded messaging, she went along with it, and they had an uneventful evening before they ostensibly all went to bed. But Isaac and Kiara continued to message one another. He had the demonstrated capacity to persuade her to do anything. He not only was able to persuade her to participate in the sex trade to the point of exposing her to risk. She was raped, but he was able to persuade her to continue even after she was raped in the sex trade. So he had the capacity to persuade her to do anything, as well as go along with his plan of him being in the home, living there, when clearly her mother objected to it. And so extreme was that emotional dependence that she had, that even after the April 22 incident, and he was able to manipulate her into dropping charges because she didn't want to endanger the relationship. And he was asked to leave the home, and she allowed him to come back. And she was so intense in that level of dependence that when there was any consideration of him leaving that home, leaving the McCulley home, she told her mother, I'll go live out on the street with him. So you have those things playing themselves out. And I think that that's how they converged that evening.
Moment, Your Honor.
Yes.
Pass the witness.
Judge, can we approach?
Jesus. What you want to approach about? I'm surprised. I have not heard the very thing I thought I was going to hear. Your nephews are up and moving. Sorry. But even though, I mean, everything I'm saying is right, this is all coercive, it's manipulative, it's financial. He knew he had our ass over a barrel. He had our ass going and coming. She was going to do whatever he did. He created the fantasy, fed the fantasy, watched it. He got his rocks off by it. But not on top of that, even leading her through an ass whooping and an assault on the job while she laying it low, spreading it wide, and giving him the proceeds, he still was able to get her to do whatever, and she never saw a red flag, a flashing light, nothing. Now, all of this can be true just for about any power dynamic, but I'm still surprised that I have not said the biggest reason why somebody would blindly follow somebody like a fucking puppy. She was 19. He was 25. And by her own testimony, they had been together for 3.5 years. Three and a half years. She says, oh, shoot, she typing. I need my other quiet keyboard. I took it to Columbus with me. I got to pull it back out. All right. I think I got everything I need. I need up and watch some about what happened there. Breaking up. Now I'm breaking up still. Like a piano. Oh no. So the goal for today is recap day. I'm trying to recap today so that I can on Keith Davis tonight and tune in the morning. What the heck? Okay, hold on. Now, why did it switch off of my mic? Can y'all hear me better now? Okay, for some reason, my mic wasn't connected. Okay, StreamYard. Leave my audio like I had it, please. Thank you. And turn my mic off. No wonder y'all couldn't hear me. The popcorn bag laying on that side. Apparently, they don't want me saying that girl was laying it low and spread it wide. Apparently. Now, what I had said was the goal, the word for the day is job. J-O-B. Word for the day is recap. Today, not in the morning. Try to do it today. Yesterday, I was so tired. I couldn't. I can't. I am blessed to assist teams that are all the way in another continent. But baby, when they 7, 8 hours ahead of us, that's whew. About took my ass out. So I didn't recap last night. But the goal for today is to recap today. I can go put the food on, recap, check the food, recap till I get done. Won't be that bad recapping today either, because I'm not saying everything that doctor said. We're just going over the basics. We will be getting Cliff's notes for this doctor. Cliff's notes and my notes, okay? Because all of this is, I mean, pretty much common sense. We know good and damn well. But to me, all of this is just because you have a dynamic of a goddamn on 25-year-old man. And I hope they don't think this jury is stupid, because y'all made a big old point the other day to point out that all the charges were dropped about him going upside that girl's head. So if you already made sure to make sure the jury knew that he was not charged and she didn't follow through with the charges, then why would that be a part of his criminal history if he was never charged? That jury ain't done. Hopefully they ain't asleep. They damn sure ain't done. They gonna know that fool got the nerve to have a criminal history, be grown, and be out here messing with somebody's child. You better watch him. You better watch. You better watch him. Because my Bali always said, if you lie, you steal. And if you steal, you know what the saying is. Can't trust them. Don't trust them.
Just a couple questions, Dr. Wellner, and I want to speak in general terms, not necessarily about the individuals involved in this case when I ask these two questions.
Okay.
In a relationship such as you've described from a theoretical point of view, coercive control and these dominant and submissive power dynamics, why does someone take the dominant stance and want to engage in these types of dominant behaviors?
Sick.
Well,
With a kid.
the way you phrase the question, I'm going to try to answer it as concisely as I can.
Okay.
Jesus.
So please understand, if I can't, it's because I'm just trying. All right.
Understood.
Now, that said, it's not theoretical. This stuff has been researched. So I'm not talking about theoretical construct. The notion of coercive control has been studied and researched. So you ask the question of, why does the person who is a dominant individual do what they do? That's unique to the individual. So in other words, the fact that the history of Mr. Apodaca's homicidal fantasy is not something that you find in every dominant individual. So how it expresses itself is different, and it converges with the expression of the dominance. Not every individual who's involved in this kind of intimate partner relationship is going to compel their partner into sex trade. That happened here. In other instances, other things happen.
Let's stay to the general construct of
Hey.
individuals who have a dominant coercive control aspect. What benefit do they derive, generally speaking, not necessarily specific to Mr. Apodaca or Ms. McCauley's case? What are the general types of benefits one might derive?
The psychological benefit is the satisfaction of control over another individual and the absolute nature of that. more control one has, then the more one feels a sense of satisfaction and comfort.
Thank you. Pass the witness, Your Honor, and I'll hand this to the court monitor.
You damn right. Satisfaction, a sick fuck.
Cross-examination, counsel.
Good afternoon, Doctor.
Nope.
Afternoon.
Me off.
Nice to see you again.
Fly in from Palm Beach?
I've actually, I flew in from Fort Lauderdale.
Fort Lauderdale.
Yes, sir.
All right. And I'm going to ask you just some general questions. A lot of what you're testifying to is based on generalities, correct?
No, it's based on the evidence of this case
Okay.
and the scientific study of the constructs that I'm referring to.
Okay. But those scientific constructs are somewhat generally applied in different cases, correct?
No, they're applied based on the specificity of the evidence and whether it fits. If there's no applicability to the components of the coercive control that I discussed or the trauma bonding, then, these are very specific qualities that I'm referring to as they approximate here.
Okay. And you have been retained by the prosecution to provide analysis in this matter, correct?
Yes, sir.
Okay. And you are a licensed practicing forensics psychiatrist?
I'm a licensed psychiatrist, yes.
Okay. And one of the, pillars of reliable psychiatric evaluation is direct face-to-face evaluations of the individuals in question, correct?
It's certainly a pillar for a diagnostic evaluation. If one wants to give a diagnosis, then it's a pillar to evaluate someone face-to-face.
You have never sat in a room with the defendant, Isaac Apodaca, correct?
I have not examined him.
You have not sat in a room with Kiara McCulley, correct?
I have not.
Okay. So you have never administered any sort of psychological diagnostic testing or assessments directly to Mr. Apodaca or Ms. McCulley, correct?
I have not.
Okay. Because you have never examined Mr. Apodaca, you're unable to provide a formal diagnosis regarding his mental state, correct?
That's correct.
Okay. And to be clear, you can't testify with any degree of medical or psychiatric certainty regarding the specific individualized mental health or psychiatric conditions of Mr. Apodaca.
I can testify to what I've testified to, but I can't testify to a diagnosis.
Okay.
In certain instances, you can testify to a diagnosis if an evaluation is not possible, and it was not possible in this case. And that I'm not testifying to diagnosis is because, in addition to not having access to Mr. Apodaca or Ms. McCulley, I don't have a complete medical record of their history, and so I don't have anything to otherwise inform it.
Okay. And if I could just ask you, if I was going to ask you this in the beginning, but if you could just answer
Sure.
when it calls for a yes or no answer, if you could just answer as such. And
I'll
there may
do
be
the
some,
best. I'll do the best I can.
some-
Yes, sir.
if you could.
He ain't about to yes,
Okay.
no, nothing.
And then, so basically, your entire perspective on this case is based on secondary documents, third-party
Kick in the
materials
head.
provided to
Kick
you,
in the
correct?
head.
It's based on, yes, it's based on the historical evidence record.
Okay. And you basically relied on materials that were specifically curated for your review, correct?
I don't know that they were curated. I asked for the complete set of documents that would inform an understanding of the time of the offense.
Okay. Now, you've never observed Mr. Apodaca interact with anyone, correct? Other than anything involved in the file of this case?
Yeah, with respect to the file of this case, I observed what I observed, whether it be the body camera, whether it be the interviews with law enforcement. Those are things that I did watch video of. It's limited to that.
Okay. So you're basically offering opinions about the psychological dynamic between Mr. Apodaca and Ms. McCauley.
Correct.
Okay, but you never sat face to face with Ms. McCauley to get her perspective directly.
I did not. I was relying
Yes
upon.
or no?
I did not.
Oh my God.
And you never got Mr. Apodaca's.
Your Honor, maybe approach.
Yeah.
Come on now.
Counsel, you may continue.
Thank you, Judge. So basically, you never got the perspective directly from Ms. McCauley or Mr. Apodaca, correct?
The only perspective that I
Yes
got.
or no, did I? Or
I got their direct perspective in the other interviews that they conducted that were recorded.
okay. And you never heard Ms. McCauley directly sitting in a room, face to face, you never heard her describe the relationship between her and Mr. Apodaca, correct? Yes or no?
I did in the context of
Did you-
reading her pretrial interview and the other interviews that she did for this case. She was, they were detailed and they were transcripted.
Okay, but doctor, you never sat down in a room with Ms. McCauley or Mr. Apodaca to discuss, for example, the dismissed domestic violence case from 2022.
I did not.
Okay. You never sat face to face with Ms. McCauley, yes or no?
I did not.
Doctor, no, I was getting to a point. Never asked Ms. McCauley if she felt logically controlled by Mr. Apodaca.
I did not ask her that question.
Okay. So you are making your analysis and assumptions based on the documents that were presented to you in this case, correct?
I'm making my analysis based on the documents and based on a range of interviews that I conducted of contributing witnesses, which included people who are acquainted with Kiera McCauley and with both of them.
Okay. Now, you have stated that the dismissed April 22 incident is relevant to the dynamic between the two. Yes or no?
Yes,
Okay. And you stated that this prior incident shows that Mr. Apodaca had psychological control over Ms. McCauley, correct?
it contributes to,
Yes or no? Doctor?
I don't believe that that was exactly my testimony, but what it does illustrate to me, if I can restate my testimony, is that it illustrates that Kiera's dependence on him was such that after a significant assault such as it was, that she prioritized maintaining the relationship, and she also prioritized keeping him in the home.
But doctor,
That's what my testimony was.
that incident was, that case was dismissed, yes or no?
Um,
Based on your review?
Yes, the case was dismissed.
Okay, and you don't know, you have no further information in conversations with Mr. Apodaca or Ms. McCauley in regards to the circumstances of why that case was dismissed, correct?
I have an understanding from the records of why it was dismissed.
Doctor, my question was, you don't have an understanding of that directly firsthand from Mr. Apodaca or Ms. McCauley?
I did not speak to either, and I did not have access to either of them. I spoke to the people I had access to.
I think he's the last one.
And you've also previously stated when we did a pretrial interview that the allegations in the April 22 case were different from the actions in this particular case, correct, doctor?
That's correct.
Okay. And when
I think he
it was
might
me
be
who
the
asked you in that interview whether it was character evidence, you didn't deny it, did you?
You'd have to show me the transcript in the context of that, because we did talk about quite a number of things.
Okay.
I'd want to see that what I actually said.
Okay. So you are basing your opinion based on maybe a prior charge that was filed and dismissed, correct?
I'm basing my opinion on her psychological dependence, on various aspects of her psychological dependence, including how that case was handled, and including her not moving forward with the complaint, which is how it came to be dismissed.
But you don't have any knowledge of whether she didn't move forward with the charges or whether the charges were bogus, correct?
I have knowledge that when police called her to speak to her about it, that Isaac was in the room.
Well,
She declined to speak to them
Doctor-
without telling them that he was in the room when they called her.
Doctor, can you
And
answer my question, yes or no? You did not speak, you did not get a firsthand account from Mr. Apodaca or Ms. McCully about what actually happened there in that April 2022 incident?
I didn't get access to speak to either of them about it.
Okay. You stated stuff like, Mr. Apodaca had invited Grace without getting permission from Kiara, correct?
That's correct.
Okay. All of these, all of this information that you provided in making your assessment were again based on your review of documents and videos, correct?
The materials of this case, yes.
Okay. So you're claiming to know Mr. Apodaca's intent based on your review of a file without speaking to him directly?
I don't believe I've testified about his intent.
Okay,
I've testified about the dynamics between the two of them, the constructs implicated by the forensic literature, the behavioral science literature, and the qualities of each of them that related directly to this event. In terms of his motivation, I haven't offered testimony about it.
okay. And you, one second. Dr. Wellner, based on your review of this case, there is no DNA evidence linking Mr. Apodaca to Ms. Jennings' death, is there? Yes or no?
Based on my understanding of the case, that's correct.
Okay. And there is no physical evidence that Mr. Apodaca touched Ms. Jennings, correct?
That's my understanding.
Yeah. Could you answer yes or no? It'd probably be better for the record too.
Well, you asked me, there's no evidence that he touched her. And I don't believe that that's what you're getting at. No, there's no evidence that there's no DNA, there's no physical evidence that he issued an assaultive or lethal blow.
Yes or no, doctor? There is no blood spatter, from what you understand, on Mr. Apodaca's clothing, correct?
That's correct.
Okay. Yes or no? There is no forensic evidence placing Mr. Apodaca at the scene during the actual stabbing, killing, correct, doctor?
Well,
Yes or no, doctor?
that's not true.
Yes or
Because,
no?
well, the answer is no. There is forensic evidence.
that's-
There's no physical evidence, but there's forensic evidence.
Okay. Placing him at the scene while the stabbing is occurring?
While the stabbing is occurring, no.
Okay. that's
Only
what I'm-
around the time.
Okay.
I'm over here screaming and I'm on mute. There you go, Tiff. He need to stop. They both need to stop, but he needs to stop because he's going to mess around and get an answer that he don't want. Now you done had this man say there is forensic evidence indicating or implying that there is evidence that your client was there when you know there's everybody else has said there's no physical evidence. Now you up here playing a game of semantics and you're going to end up on the shit end of the stick.
Dr. Boulder, you don't actually know what Mr. Apodaca expected would happen when Grace was invited over, correct? Yes or no?
It's an interesting question.
But I asked for, I mean, Can you-
No,
can you answer it
I have to think about it before I answer it, because I think only he knows what he was capable of persuading her to do, but I don't know what his objectives or anticipated outcome of that night when he invited her over. That's
Okay.
correct.
yeah, okay. That answers it well. Thank you. You know, Dr. Wellner, a major part of your opinion rests on the review of possibly some text messages.
You mean the Facebook messaging?
Yeah, Facebook messages.
It certainly contributes to my opinion and was borne out from various aspects of what I got from the documentation and the interviews and my own interviews.
Okay. So basically what you've been reviewing is what we've been going over here this week, correct?
Objection, Your Honor.
I can move on.
Yes, and just,
Understood.
yep, move on.
Okay. Okay. Dr. Wellner, I'm now going to shift over towards interrogation tactics, coercion. In regards to interrogation, you had stated that that's an area that you have expertise in, correct?
Yes, I've published in that area and I've researched some.
Okay. And in regard to that, what you did review the interrogation in this case?
I did.
Okay. And what specific interrogation techniques did you identify as having been used during the interrogation?
I think that the detective, after giving him an opportunity to elaborate, confronted him with the Facebook messaging and the contradictions of his account.
Okay.
And that was essentially a principal technique that I observed, that he was asked to explain and to reconcile the contradictions in his account from what was showing up in the Facebook messaging.
Okay. And you are familiar with the read technique, correct?
I am.
Of interrogation?
Yes.
You're also familiar with the piece model?
Yes.
Okay. Can you explain the read technique of interrogation?
Well, the
I'll allow it.
I mean, the read technique is an approach in which various techniques are employed in order to bring a suspect from denial to confession. The peace technique offers all of the qualities of the read technique, but does not employ confrontation.
Okay. And then are you familiar within these methods in regards to minimization tactics?
Yes.
Okay. Minimization tactics were employed, were utilized in this interrogation, correct?
I can't say that they were. Minimization refers to the diminishing the seriousness of what happened. I don't recall the detective diminishing the seriousness of Grace Jennings' murder. Minimization is diminishing the consequences of what's going to happen to somebody. I do recall that at the beginning of the interrogation that Mr. Apodaca was told that he wasn't a suspect. And I believe that at the beginning of the interrogation, he may not have been.
Okay. Okay.
But I think that when everything came down and he was being actually presented with what was in the Facebook messaging, which then became accessible through the fortuitous access to his phone, then I don't think that he was told that he would not be held criminally responsible in exchange for, or that he would be treated in a diminished way, which is what legal minimization refers to.
Okay. So I'm going to go through some of the exact parts of the interrogation.
Sure.
In the beginning where the detective discusses Halloween and what he's going to be doing for Halloween. Do you remember that part?
Sure.
Okay. That could be an implied promise tactic, correct?
Can you show it to me? Because in my own mind, I'm inclined not to agree with you, but you may be right, and I want to see what you're referring to.
Okay. Let's do this instead of having to get, if the detective were to talk about Halloween plans,
Yes.
okay, would that, early on, in the interrogation, what are your plans for Halloween? Are you gonna dress up? All that. Would that be indicative of a false promise?
No, that's referred to as rapport building,
Okay,
and that's an interrogation technique.
but that is an interrogation tactic.
Yes.
Okay.
You build rapport with someone because if they're comfortable, they'll talk to you. You hope.
Okay.
But they're less likely to talk to you if no rapport is built.
Can you discuss maximization tactics?
Yes.
Okay. Can you explain what that is?
Maximization is one amplifies the seriousness of an offense. And I can hardly imagine how the murder of Grace Jennings, such as it was, could be maximized. I mean, it was what it was.
Okay.
And I meant to say
So-
over amplification.
There's no question. Wait for the next question.
Thank you, Judge. Now, a long interrogation, would that be concerning in regards to a possible coercion?
It depends what happens during the long interrogation. It depends on the conditions of an interrogation. If a detective or police officer creates coercive conditions within an interrogation, it doesn't have to take too long. And length of interrogation can be affected by any range of factors, but it doesn't create coercion. It creates a lot of boredom, may contribute to a suspect falling asleep because they have to wait a long time.
Okay.
But no.
And generally, is lying a tactic in interrogations?
You mean when officers lie to a suspect?
Yes.
Some officers will lie during interrogation. It's not as commonly used if you look at surveys of police officers, but it's some officers will lie and see where it goes and what it elicits.
Okay. Creating a narrative of guilt that they want the suspect to adhere to?
It's not an interrogation tactic
It happens
because
in interrogations?
it may at some point that there are various theories that may get tested out, but it's not so much a tactic as it is something that happens in interrogation. The read technique that you speak of, they're not taught to create narratives.
In any
they're
way you
taught to
can.
elicit input. So if it's something that a detective does or law enforcement does, if anything, it's not necessarily encouraged because it may prevent other information from coming to light. But it's not something that contributes to a coercive atmosphere. It's just a qualitative technique issue.
Okay. Psychological vulnerabilities of a subject. Again, that's something that you would have to interact directly with the subject to know about, correct?
You can get a lot of historical data about someone's psychological vulnerability in an interrogation. The opportunity to examine somebody doesn't reflect on how they were at that time. As someone that you see at a point in time after they've been arrested and been in custody may be very affected in various ways and may not have had the vulnerabilities that they had at the time of interrogation. And that's also to include strengths and the ability to resist somebody's questioning. So an assessment of vulnerability, it refers to the assessment of a person's vulnerability to give a false confession to a crime that they did not commit. But it also encompasses looking at the strengths that a person has to be in an interrogation, whether they're guilty or innocent, and to parry away any efforts from a detective or an officer to get information from them.
Okay. And did you interview any of the interrogating officers?
I did not.
Okay. One second, Judge. Nothing further, Your Honor. Thank you.
Redirect.
Yes, Your Honor. Dr. Wellner, let's start where defense left off and asking about interrogation techniques and false confessions.
Yes.
Okay. What is a false confession?
A false confession is a confession that somebody makes to a crime that they could not possibly have committed.
I was about to
Because, for
say, why we-
example,
what is this?
let's say that you confess to a murder, but that murder happened when you weren't in Santa Fe, but you were in Fort Lauderdale. Well, that would be a false confession. Or you confess to a murder.
Doctor, don't refer to specific jurors in your examples.
Okay. Let's say that someone else can confess to a murder or sex assault, and the physical evidence of that sex assault demonstrated another person's bodily fluids inside someone. And so the nature of what was physically described could not possibly have taken place. So it's a confession to an event for which the physical evidence, and actually not just the physical evidence, but the digital evidence, and that was the testimony I gave earlier about forensic evidence, many kinds of forensic evidence, wholly makes it impossible that the person could have participated at all.
That goes to my next question. Then you did differentiate between forensic evidence and physical evidence. Can you just explain that difference?
There are many kinds of forensic evidence. There's the evidence that we rely on in behavioral sciences is human evidence. When I interview someone, it's human evidence, and I take it in. There's physical evidence from the DNA that's been referred to. There's digital evidence where there's camera, there's photography, and you can prove that someone was where they were in a particular place. There's documentary evidence, which is it is what it is, and it was created when it was created, and was said what was said. So these are various forms of evidence that converge to inform our understanding of what it is that we're supposed to evaluate.
To you, from a forensic psychiatric perspective, is the lack of physical evidence that implicates Isaac Apodaca, in other words, the fact that his DNA isn't on the sword or his fingerprints aren't on the sword, is that forensically, psychiatrically relevant to you in your assessment of the relationship between Kiara and Isaac?
No, I was asked to evaluate the dynamics between them. I was asked to evaluate the psychiatric and psychological constructs that might have relevance. And I was asked to evaluate the qualities of each and how they culminated in this event.
You were asked on cross, and then you wanted to clarify something. I just wanted to give you the opportunity to do so. You were asked about the concept of maximization in a interview of a suspect, and you said something about amplification versus over amplification. Can you just clarify what you were talking about?
Well, I did not want to misspeak. If you an example that I can refer to is if someone is being questioned about an alleged physically or sexually inappropriate act that exposes itself to certain charges. Maximization would be, you're going to go to prison forever. You know, you're going to get life for this, or you're going to get 50 years for this. And so you're amplifying the significance of the legal significance of the event in order to impact the suspect to think that the potential consequences are greater than they are. So you've over amplified it. So my point is, you can't over amplify this murder. It is what it is. It's not, you know, that doesn't have relevance to the context in which maximization is studied and applied.
Yes.
Not longer than an hour. Sorry, guys, my food came. I don't know if it's a chair or a door, but that thing be screaming.
Just to be clear, you're not making any diagnoses in this case.
No.
And you had the opportunity to observe Kiara McCauley's testimony today.
I did.
And just generally speaking, did those observations factor into your opinion, the opinions you've already testified to in this case?
Yes, the information that she provided and my observations, yes.
A brief moment, Your Honor. And then just finally,
I don't know if I
terms
can
of
say
the
mine, Terry.
defense questioning about coercion and the source of the interview. In your review of Isaac Apodaca's interview, were coercive techniques utilized?
No.
Oh, Keisha, there's a way.
Your Honor?
He'd have the closing that damn attorney gave Carmelo. I can't tell you what's the right thing to do. You'll know the right thing once you get there. Do what's in your heart. I can't tell you what verdict to pick. That's exactly what he have. This is the type of person deserve that type of closing. Because what you want me to do with this? I don't know how much of a deal it'd be, Nikki. It'd be a plea, though. Shay pissed me off, but this is the only time I could ever think that where it would make sense. Sir, why do y'all keep coming with a false confession? Like it was no way possible that he could have been there, done it, talked to that girl, anything during that time frame. His text messages matched the entire fucking crime. Narrated it. You don't even have to ask, who was it? What time she come over? Where did y'all sleep? Did she fall asleep? What time did it happen? It's narrated in the damn messages. Didn't even erase the messages. All them jail calls, whoever's listening, he was saying all kind of shit. And called the girl the damn KGB.
Dr. Wellner, is it unusual for you to make determinations or offer opinions in a case without talking to the individuals involved?
Dominic, I think he is.
Many areas across the spectrum of forensic psychiatry where interviews are not done, and in certain instances, they're not even possible. And in certain instances, you're actually allowed to give a diagnosis even without an interview when you are not given access to someone, but you have a complete record. The objective is for you to make an evidence-based determination that's inclusive of all the evidence that can be made available to you. If you don't have enough information, you don't offer an opinion. But if you have enough information and it's inclusive of all the information that's possible, then there are various areas in the forensic psychiatry arena where you do.
You're beyond the scope of the question. I'm going to ask him the question again directly and give a direct answer without moving into other areas.
Is offering an opinion in a case where you have not personally interviewed the individuals involved something that you do regularly?
Just say yes.
It's something that forensic psychiatrists do as a matter of commonplace practice.
Just say yes.
Nothing further, Your Honor. We will reserve the witness.
Ladies and gentlemen, I think we'll go ahead.
Yeah, he looking, no, the fuck you ain't gonna reserve me, and I just came from Florida.
Attorneys will stay in contact with you and let you know if you're going to be recalled, but you're free to step down as soon as the jury calls.
Okay, thank you.
All rise.
Well, they can't call his mama now. That would be the only person that would regurgitate all the same things. So they can't call his mama. He gonna have to get up there. He done messed that up.
You may step down. Don't discuss your testimony with any of the other witnesses during the break. And again, the attorneys will stay in touch with you and let you know if you need to return. Counsel, 15-minute recess.
Thank you, Judge.
We're off the record. Send this again.
Hey, Jay.
He pretty much gave us everything that we knew that we kind of already knew, or most folks with common sense had put together in a way that only a doctor can, and that's how folks will be more accepting of the information. But to be all the way freaking honest, baby, you ain't say the thing that it was. That's a child, a grown ass man and a child. Who can't manipulate a child? What adult would you not expect to be able to guide and therefore, in no other uncertain terms, manipulate a child? Period. And to be honest, she seemed like she was a damn handful. So I hate to say it because it's sick, but her mama probably felt like he had more control in this. Therefore, she didn't have to deal with her or handle her. Craziness. Are we all live? Are we up to date? We are. All right, guys. We'll be back in like 10 minutes.
It is 3:55. Let's spend a moment before we bring the jury back in and organize the rest of the day. Ms. Murphy, on behalf of the state, who's your next witness?
Your Honor, we will rest our case today, and we'd ask to be able to do so in front of
Woo!
Okay. We need to do directed verdict motions after that.
I bet you better not do no directed nothing.
I think I'm gonna, once you rest, I'm gonna send the jury home for the evening. We'll do directed verdict motions, and then this system is not functioning. I can't bring things up. I was trying to bring up the instructions and they just wouldn't load. File and serve is also down right now, so I don't know what's going on with the Odyssey system.
I think it may be partially the courthouse internet too.
Yeah, no, all of it seems to be either lagging or just not working. So before I let you go, I'd like to take a first glance at the instructions, even though we're not done with the case, just to see if there's anything there that we need to work on over the evening. But I'll hear directed verdict motions first and make decisions on those motions. And then we'll use the rest of whatever we have left until about 5 o'clock to do whatever else we can get done this afternoon. What I'm thinking about is, don't know, counsel, and you don't have to make a decision yet about who you would call as witnesses, and if the defendant was going to exercise his right either to testify or to rely on his presumption of innocence. The only reason I'm thinking about it now is it would impact potentially when I have the jury come back in the morning. If we're going to be working on jury instructions early, I probably wouldn't have them come in until about 9 o'clock tomorrow. In fact, I think I'll do that anyway. And that way we'll have the jury come back at 9 o'clock tomorrow morning, and then we'll continue with the cases in chief, and then any rebuttal if necessary, if any rebuttal witnesses are going to be called. But I want you to have the evening to have the conversation with your client. If you already haven't made that decision, he gets to ultimately decide. So
Judge, we spoke to him.
What's that?
We spoke to him about that earlier, and we decided that we will not be calling.
Okay.
But not.
We'll have that colloquy on the record with him after the state is rested, and when we get to that point, because I need to have that conversation with him.
Understood.
So I'll have the jury come back at 9 tomorrow morning, and I'll have you all back here at 8 o'clock. I only have one hearing in the afternoon. That's a video hearing that should be quick at 3 o'clock. So if the jury's deliberating, or even if we're in closings, we have to stop at 3 because they're calling in from DOC. And that's of everything that I had for tomorrow's calendar. That's the only thing that I kept on. Anyway. Anything else before we bring the jury back in?
No, nothing from the state judge.
Okay.
Not from defense.
Okay, let's have them come in. I'll have you rest. I'll give them instructions, and then we'll take a short recess, and then we'll come back and hear directed verdict motions.
That must be the door. No, everyone has not rested. The state, once the jury comes in, the state will formally rest in front of the jury. And then the jury is going to be dismissed for the day. Then they're going to allow the defense to make their directed verdict or motion for a directed verdict. Once they go through those motions, then the judge is going to have his colloquy with Isaac about whether or not he wants to testify. Sounds like they've already decided that he's not going to, but he'll have that discussion with the judge. And then they should be taking the first glance at jury instructions, possibly. But the jury's getting ready to go home. That hair, the middle of it sticks out like the old school Dennis the Menace cartoon. but they're still going to have to determine if they're going to call anyone. So we actually won't know if the if the defense is going to put on a case besides Isaac. I don't think they're going to try to call Mama, but they might try it just to say that he wasn't allowed a witness or something for an appeal. But the defense has all night come to their conclusion about whether or not they're going to put on a case, and we'll find out in the morning at 8 a.m. 8 a.m. Pacific, 11 a.m. Eastern. I'm not sure. I thought he was the investigator, but I'm not sure. Now, Keisha, they got the defendant.
You may be seated in the courtroom, ladies and gentlemen. Okay, we are back on the record with our jury, counsel, and Mr. Apodaca present. We continue in the state's case in chief. Ms. Murphy.
Your Honor, at this time, the state of New Mexico rests its case.
Ladies and gentlemen, at this point in time in the case, with the state having rested in its case in chief, there are matters I need to take up with the attorneys outside your presence, and that will take some time. So instead of keeping you back there and then maybe only bringing you in for a couple minutes before 5 o'clock, I'm just going to go ahead and release you for the day. And I'm also going to ask you to return later than you have been coming in tomorrow morning. I'm going to ask you to be here at 9 a.m. Okay. So just to kind of inform you, we are at this point in time in the case where we thought we would be this time yesterday. So we are behind, and so we will extend it tomorrow. And as I asked you before, to look even into Thursday potentially, if necessary, if your deliberations would potentially take you into Thursday, to make sure. I did inquire with the jury division to see if any of you had already been excused for Wednesday, Thursday, and Friday, and what I was told is no one had been. So over the evening, don't seek out any information about the case. Don't speak to anyone about the case. Don't make up your mind about any of the issues. You have not heard all of the case or the instructions of law. When you return tomorrow morning, meet the bailiff again on the second floor. I want to make sure. Why I paused, ladies and gentlemen, is I'm thinking about the schedule of which lights they're replacing in the building. And I know they're supposed to be somewhere on the second floor tomorrow, but I don't think it's out in the public areas. I think it's in the back. So just go ahead and meet the bailiff at the end of the hall on the second floor at 9 a.m. He'll bring you back up, and then we'll bring you back into the courtroom as soon as we're ready to get started. All right, then. Have a good evening, and we'll see you tomorrow morning at 9 o'clock.
All rise.
May be seated in the courtroom. Let's take about a 5-minute break. I need to go grab one other thing in the back, and then I'll come and hear directed verdict motions. We're off. I'll be back at 10 after. So we're off the record until then.
I'm trying to figure out in the light most favorable to the state. Even if it wasn't in the light most favorable to the state, what is it that we're going to talk about when it comes to a directed verdict? Anybody know? In most cases, yeah, they have to get themselves back and forth. We don't know. They have till tomorrow morning, Kaylane, to decide. So the defense gets to go home and sleep on it, and decide if they're going to put on a case. If so, they'll let the judge know where we're going with this at it'll be 8 a.m. my time, but 8 a.m. Pacific or 11 a.m. Eastern tomorrow. To be honest, I think you're right. He's going to harp on the fact that he didn't actually do this, and that Kiara had a personal bone to pick with Grace anyway. But I still think the only thing that he can actually do is somehow attack, discredit, or prove that he didn't make those text messages. And the sad part about that is, even if Kiara was crazy enough to text herself from one of his phones or additional phones, they did find a lot of phones, you was in the same room with her, so it's not going to look like you was at a different location. So in the terms of a directed verdict, it would still be a question for the trier of fact or a question for the jury to decide. He planted the entire homicidal fantasy into he knew that that girl was paranoid, twisted, and everything else in the head. And he played on it like a puppet, fed it homicidal tendencies. Glad you made it home safe, Laura. Exactly, Keisha, because he went in there to see if mom could hear it or to keep mom distracted. Never told mom Grace was coming to her property, period, knowing they had been beefing. Look at his head. Look at it. Look at it. He just look. I can't believe this fool. Just all this because you're getting some sick, twisted satisfaction out of manipulating somebody and controlling them. And that shit blew up in your face because the girl was harder than you, had bigger balls than you, actually did
Let's
this.
go back on the record.
Oh, excuse me.
We reconvene with the state and defense and Mr. Apodaca present outside the hearing in presence of the jury. The state having rested in its case in chief, are there motions for the defense?
Yes, Judge, defense would motion for directed verdict at this time.
There's two, one or both counts.
Both counts, Your Honor.
Go ahead, counsel.
Thank you. So, Your Honor, right now we are motioning for directed verdict again as to count one, first degree murder, willful and deliberate under the theory of accessory liability, and count two, conspiracy to commit first degree murder. And our argument here, Judge, is first of all, the elements in regards to first degree murder, willful and deliberate. State is alleging here that on or about October 29th, 2022, that the defendant, Isaac Apodaca, killed Grace Jennings with a deliberate intention to take away the life of or any other human being. I'll get to deliberate intention and the case law here in New Mexico in regards to that, and how it would apply to Isaac in a bit. But what I do want to just kind of go into is the physical and scientific evidence in this case that basically separates the defendant from in any way aiding or encouraging or intending anything to happen in this particular case. The murder weapon, the sword used to kill Grace Jennings, does not have any physical connection to the defendant, Mr. Apodaca, as was testified to by multiple witnesses in the case. Defendant Apodaca is completely excluded as a source of the DNA profile obtained from both the blade and the handle of the weapon. That was not the case for Ms. McCauley, but in regards to Mr. Apodaca, it's completely excluded. There was also an exclusion of latent prints. The analysis showed that the defendant, Mr. Apodaca, was excluded from anything regarding any sort of fingerprints on the weapon. Now, in regards to aiding and abetting, I mean, mere presence, mental acquiescence, or failure to prevent a crime, or failing to prevent a crime does not establish accessory liability under New Mexico law. Basically, the state's relying on the text messages, and the crime scene kind of demonstrates that when the act occurred, Mr. Apodaca did not wield, touch, or hold the weapon. So we're basically completely basing this on messages. I know people argue that there's also that statement in that interrogation. The statements made
You got to be
after
shitting
the
me.
detective tried to get him to acquiesce to what he was, what the detective was saying. But if we look at what was actually, what actually happened here, and even for the sake of argument, if we say we're acknowledging that some of those messages could have been Mr. Apodaca's, I don't think that that's fully been established. But if we were to make that argument, even then, there's nothing here showing that anything went beyond just mere acquiescence or possible presence there. And it was also established the testimony that the timeline didn't fit, and Mr. Apodaca was not present there as far as in the detached garage at the time of the killing. So, Your Honor, under New Mexico law, I mean, that's kind of where I would say that accessory liability has not been established here. I know the state's been trying to make this argument that Mr. Apodaca is somehow a grand mastermind based on some message and different things. But I mean, there was Kiana Aguilar who testified that she didn't take Kiara seriously, and it was pretty clear that nobody really expected her to actually act out on this. And there was also a lot of testimony how Mr. Apodaca was staying with his mom, with Ms. McCauley. The state's really trying to, throw everything they can at us with Dr. Wellner and say that somehow Mr. Apodaca was coerced, or Mr. Apodaca coerced and controlled Ms. McCauley. But I think the evidence here is that Ms. McCauley was in charge of this plan. She was the mastermind behind this. Mr. Apodaca was staying with her mom and Ms. McCauley, but there's nothing here that a reasonable judge or jury no reasonable judge or jury based on the evidence presented could find the defendant here guilty beyond a reasonable doubt of first-degree deliberate murder. I mean, under New Mexico law, deliberate intention refers to the specific state of mind required to support a conviction for first-degree murder. I've already established that accomplice liability is not present here. There's nothing showing that Mr. Apodaca intended for Ms. McCauley to die. There's nothing showing that he actually
we about as reasonable as they come.
Ms. McCauley said seriously, or that he was seriously encouraging her to do anything in regards to the messages. Basically, they were highly erratic text messages, but the physical reality is that there was nothing in those messages. There was nothing linking Mr. Apodaca to the scene. Now, in regards to willful and deliberate first-degree murder, I mean, deliberate intention refers to the specific state of mind required to support a conviction for first-degree willful, deliberate, and premeditated murder under State v. Garcia, State v. Duran, State v. Cunningham. The concept of deliberate intention required that the defendant form the intent to kill the victim prior to committing the act.
Well, what was
Nothing has been
the next step?
established in regards to that. In regards, the accomplice liability and instruction says that he encouraged and intended, and there would have to be a deliberate intent. And in regards to deliberate intention, the word deliberate means arrived at or determined upon as a result of careful thought and the weighing of consideration for and against the proposed course of action. Again, that's based on State v. Duran. State v. Crawford, there was absolutely no evidence here that there was any sort of deliberate intent, that this was a result of any sort of careful thought of weighing anything. In fact, Ms. McCulley testified that she was the one stabbing Ms. Jennings, and then while she was stabbing Ms. Jennings, she said she told Ms. Jennings that if she apologized, if Ms. Jennings apologized, then she would stop. So Ms. McCulley was in complete control of that ship, Your Honor, not Mr. Apodaca. The weighing requirement also to constitute a deliberate killing, the slayer must weigh and consider the question of killing and the slayer's reasons for and against making such a choice. There's nothing here showing that Mr. Apodaca in any way was weighing this, or was he serious about doing anything to Ms. McCulley. Again, Ms. McCulley was running this ship, and as far as decision making, the time frame, be a calculated judgment and decision. There was no calculated judgment here. It was by Mr. Apodaca. It was Ms.
Not all the texts are his,
who
Dominique.
carefully weighed the options.
Established that all the texts were his.
Killing Miss Jennings. And there could be arguments, here that I don't believe that any form of murder here applies to Mr. Apodaca, but certainly there was no deliberate intent here, and the state does not establish that in any way. So based on that, Your Honor, I believe that the first degree murder based on a theory of accomplice liability charge should be dismissed, because no reasonable judge or jury based on the testimony and evidence presented could find the defendant guilty of that in the light most favorable to the state. Now, in regards to conspiracy to commit first degree murder, what the state is alleging is that on or about October 29, 2022, the above named defendant did by words or acts agree together with another person to commit first degree willful deliberate murder, and they intended to commit first degree murder, willful and deliberate, a second degree felony. Now, Your Honor, again, there was a rejection of the action, Your Honor. If you look at the timeline of the messages, there was, I think Ms. McCulley herself stated that she can't physically perform the act. Mr. Apodaca stated he didn't want to do anything regarding that. And there was basically no real organized framework in regard to this. And also there was evidence that established that the defendant, Mr. Apodaca, left when he was restroom, returned, found the victim deceased, and then instead of acting to conceal anything, he immediately contacted his mother, Ms. Montoya, and directly contacted emergency dispatch to report that Ms. McCulley killed someone with the sword. So if we're going to say that there's a conspiracy here where this is alleged to have happened, by a single individual, but it was immediately met with emergency intervention by Mr. Apodaca, who the state is alleging is a co-conspirator, Your Honor. So based on that, the state's argument basically is that Mr. Apodaca somehow conspired to commit this crime and then decided to just go turn himself in and wait for cops to arrive at the AP wireless store, Your Honor. That is not indicative of a conspiracy, and I don't believe that in the light most favorable to the state, a reasonable judge or jury could find the defendant guilty of that count as well. If I can have 1 second.
Yes.
Nothing further, Your Honor. Thank you.
Response for the state.
Thank you, Your Honor.
Just say fuck what he talking about. I wouldn't even respond.
Judge, so
Well,
directed verdict is really only appropriate in cases that are tried to a jury. If this were a bench trial, then the court would just make a decision as to guilt or innocence. But what directed verdict does is that it requires the court to decide at the conclusion of the state's case whether the direct
You know
or
what it is.
circumstantial evidence admitted at trial, together with all reasonable inferences to be drawn therefrom, will sustain a finding of guilt beyond a reasonable doubt. That is taken directly from Mexico Rules Annotated 5-607E and K. Also, State v. Baca, 2015, Mexico
Oh,
Supreme Court
Jesus.
021 at paragraph 31. A directed verdict is appropriate if there is no legally sufficient evidentiary basis for a reasonable jury to rule in favor of the non-moving party. That's directly from State v. Garcia, 2017, Westlaw 1373443 at paragraph 3. The proper standard of review for a denial of a directed
What did
motion
you
is
say?
sufficiency of the evidence. That's out of State v. Sena, 2008, New Mexico Supreme Court, 053 at paragraph 10. The test for sufficiency
Wow.
of the evidence is whether substantial evidence of either a
Have
direct
my
or
food,
circumstantial
y'all.
nature exists to support a verdict of guilt beyond a reasonable doubt with respect to every element essential to a conviction. That's also from State v. Sena. We do not weigh, and this is, I'm quoting the case, we do not weigh evidence or substitute our judgment for that of the trial court so long as the jury was presented with such relevant evidence as a reasonable mind might accept as adequate to support its verdict. That is out of State v. Coleman, 2011, New Mexico Court of Appeals 087, paragraph 19. A reviewing court must view the evidence in the light most favorable to the state, resolving all conflicts therein and indulging all permissible inferences therefrom in favor of the verdict. That is out of State v. Graham, 2005, New Mexico Supreme Court 004 at paragraph 6. Essentially, Judge, the jury instructions for count 1, willful and deliberate first-degree homicide, is element number 1, the defendant killed Grace Jennings. Number 2, the killing was with the deliberate intention to take away the life of Grace Jennings or any other human being, and this happened in New Mexico on October 29th, 2022. Further, there is a definition of deliberate intention, but then if we move on to the instruction right after that, or proposed instruction right after that, talks about how a defendant may be found guilty of a crime even though the defendant did not do the acts constituting the crime if the state proves to your satisfaction beyond a reasonable doubt each of the following elements.
You're talking about a different instruction, 28.
2822.
21 or 22.
2822, correct, Judge.
Go
And
ahead.
I'm sorry?
Go ahead.
Thank you. And those elements say the defendant intended that another person commit the crime. Number 2, another person committed the crime. And number 3, the defendant helped, encouraged, or caused the crime to be committed. If we then look at the evidence that was presented, Judge, we have testimony from the first responders about the scene of the homicide. There were numerous cuts and stab wounds to the body of Grace Jennings. There was corroborated testimony by Dr. Emily Hilmerich that went into a much greater detail about the severity of those wounds. Dr. Hilmerich also testified that the manner of death was homicide. She testified that a number of those injuries would have been fatal by themselves. The state also presented evidence that the homicide itself was committed by Kiara McCauley.
I'll say it again.
Other evidence presented was the text messages and the Facebook Messenger text that showed the plan and preparation between Kiara McCauley and Isaac Apodaca. This premeditation, which is not actually part of our jury instruction anymore, but is still part of the statute for first-degree homicide, shows that deliberate intent with which both defendants acted under is most evident in those text messages. But also, the defense witness, Kiana Aguilar, stated that Kiara told her that she was going to kill Grace Jennings and that Isaac would be there. There were also the text messages from the defendant about simply stating, "End her joy," telling Kiara how to stick it in, what direction to cut. All of those show that premeditation because those texts are about how to commit the homicide that occurred hours before those texts talk about the actual homicide, and those texts were sent just hours before the actual homicide was committed. We also have Kiara's text asking for help, either in the form of the defendant actually committing the homicide or in making her angry enough so that she could commit the homicide. Also, Judge, we cannot forget the defendant's final adoption of those text messages in the interview with Sergeant Vigil, as well as a statement that he wanted Grace dead and wanted Kiara to kill Grace. In looking at whether the defendant helped, encouraged, or caused the homicide, those texts show the many different avenues the defendant took to encourage Kiara McCauley to commit the crime. Based on those text messages, it is very clear that the plan and preparation began actually on October 28, 2022, and was actually realized the next day on October 29th, 2022.
Dominique, how did she know
Aspects of
I'm
the
here?
plan include leading Grace to the park where Kiara was waiting. The defendant actually didn't follow through with that. The Operation Fake Kickout, and the evidence from the defendant's phone telling Kiara that he would take care of the cleanup. It is also clear by those text messages that the defendant encouraged Kiara McCauley to commit the homicide. Not going through every piece of evidence submitted and presented, but in those text messages, Judge, he did tell her that she would gain access to the black market and could get paid. He also very clearly intended that the crime be committed by reading those text messages that he sent to Kiara McCauley. The defendant's statement that Grace would die instantly after telling Kiara to use the dagger against Grace, that's further evidence of his intent to kill. It is also clear by those text messages that the defendant encouraged Kiara McCauley to commit the homicide, but also, again, Judge, we do have the defendant's final adoption of those text messages to Sergeant Vigil. Finally, we also have the testimony of Dr. Michael Wellner and his explanation of what he called coercive control. And really that does a lot to, I think, not only assist the jury, but to, assist sort of everyone that has been following this case to understand how one person can actually have so much power and control over someone else to the point that they're actually willing to commit murder. Finally, Judge, looking at the conspiracy, let me just briefly go through those elements. Those three elements are going to be this, Judge. The defendant and another person by words or acts agreed together to commit murder in the first degree. The defendant and the other person intended to commit murder in the first degree, and this happened in New Mexico on or about October 29th, 2022. In looking at that, again, we have to go back to those text messages and the testimony, and the state has shown that there was an agreement to kill Grace Jennings. There was a great deal of planning to include, again, Operation Fake Kickout, and essentially this was not a spontaneous event that happened between Kiara and Grace. The defendant was also the other party involved in this. There was the plan to kill Grace, and then they followed up that plan by talking about a cleanup. It was at this cleanup portion, Judge, that actually it's evidenced by the final internet search of how to dispose of a body, which was taken directly from the defendant's phone, that it appears as if the plan completely fell apart. But just because the plan fell apart does not mean that the conspiracy did not happen. And again, Judge, please do not forget that the defendant adopted all of those statements in those text messages as his own. So in the light most favorable to the state, it is very clear that a reasonable jury could find the defendant guilty beyond a reasonable doubt of both charges, first-degree homicide by accessory and conspiracy to commit first-degree homicide. And the state respectfully asks this court to deny the defendant's motion.
Thank you, counsel. The court makes the following, actually, any brief reply?
Yeah, briefly, Judge.
Go ahead.
Your Honor. So, I mean, how to dispose of a body was the search was after the fact. Mr. Apodaca was clearly under a lot of duress at that time. Don't know the context of what was going on, if he was being threatened or different things, but there's nothing showing that he had a willful, deliberate or premeditated intent to commit this crime before the fact, Your Honor. Wellner's testimony in regards to this directed verdict, and I think I'm going to argue with the jury as well, if it gets to the jury, should be taken with a grain of salt, Your Honor. I mean, there's nothing, the jury instructions for accomplice liability are clear, Your Honor. It's in regards to encouraging, whether there was intent and encouragement. And as I've said, mere presence alone is not enough. Dr. Wellner is going into this long history of coercion and control that existed based on documents and videos that by his own acknowledgement did not even speak to Mr. Apodaca or Ms. McCulley. He's basing it off of some reports or consideration of sex work, as the state's trying to make it out to be, as well as a dismissed domestic violence charge, Your Honor. But there's nothing here showing that Isaac Apodaca acted in any way to encourage or intended Kiara McCulley to kill Grace Jennings on that particular day. And that's what we're here to discuss, Your Honor. And in regards to Kiana Aguilar, that Mr. Long brought up, my understanding, I don't have the exact, I mean, I know the court has the luxury of the exact transcripts, but if I remember correctly, I clarified with Ms. Aguilar that Ms. McCulley had said that she would have Isaac there, or something to that extent. So it was not like Isaac already knew what was going on. Isaac, and she testified that Isaac didn't know, Isaac wasn't there. Isaac wasn't hearing any of this, but basically Kiara saying Isaac will be there. That could be because Kiara stays with Isaac, or Kiara knows that she herself can manipulate Isaac, Your Honor. So based on that, Your Honor, again, I think the first degree murder charge should be dismissed. And again, for some of the similar points, as well as the arguments that I made initially, I would argue that in the light most favorable state, that the conspiracy charge should also be dismissed by virtue of the fact that
They might have done better by villainizing Kiara.
guilty of that crime. And as far as the bench trial thing, I have
To
actually
do what she want. Can't nobody tell her what to
a
do.
directed verdict on a bench trial here in Santa Fe.
Her mama couldn't even
bench
keep her in school.
One directed verdict. So it can happen in a bench trial.
Well, if
Or
her mama
in
can't
a
tell her
jury
what to
trial.
do, how can I tell her what to do? I mean, you could have tried anything.
Just a second. All right, these are the court's findings of facts, conclusions of law, ruling, and observations. The state is prosecuting this case as first-degree murder. It cites to, and the court has before it and has reviewed our UGI instruction 14201, which is the elements instruction for first-degree murder under the law of the state of New Mexico. The standard of review at directed verdict.
I know,
is
Ashford,
that
it's
all
sounded better than
inferences
that.
and all evidence is viewed in the light most favorable to the non-moving party at this stage, meaning the state. The court does not weigh the evidence. That is the jury's realm, their decision to make. The court must decide and determine whether or not there's substantial evidence as to the elements upon which a jury could reasonably conclude beyond a reasonable doubt that the crime had been committed. So starting with 14201, the defense has argued that there is no physical evidence that their client, Mr. Apodaca, actually committed the murder of Grace Jennings. The state has not prosecuted this under a theory that he actually delivered any of the blows, restrained her, anything like that. It is that he, as an aider and abettor, created a scenario or situation upon which the deliberate intentional murder occurred. There is evidence before this jury about we'll just start with the day before the killing as to how Grace Jennings came to be with Ms. McCulley and Mr. Apodaca. There is testimony before the jury as to the relationships between Ms. Jennings and Ms. McCulley, There is also extensive testimony and expert testimony and opinion as to the relationship between Ms. McCulley and Mr. Apodaca. These all go, and this is all substantial evidence in the court's view, of an intention to kill. The planning necessary and the sequence of events that occurred both before, during the killing, and in the time
There you
frame
go.
immediately thereafter. The state has to prove, and the court finds that
There
there
you
is
go.
substantial
How
evidence
did Grace
that
come
the
to
jury
be
could
with him
reasonably
that day?
conclude that
It
the
wasn't
killing
because of
of
Kiara.
Ms. Jennings
You orchestrated that
was
shit.
an intentional,
You set
deliberate
her
murder.
up.
The law then requires us to look at 142822, which is the aiding and abetting accessory to a crime theory. And there are three elements. One, the defendant intended that another person commit the crime. Two, another person committed the crime. And three, the defendant helped, encouraged, or caused the crime to be committed. There is testimony before this jury as to element number one, that the defendant intended that the crime be committed by another person. The extensive multiple hour text exchange between the individuals, the communications regarding the location initially at a park in close proximity to the residence, the conversation that occurred over multiple hours throughout the night into the
Raise your hand.
following day,
Say, can I still take that,
with,
please?
encouragement, possible alternatives,
Raise your hand. I'm gonna go ahead and
potentially
take
an
that, please.
alternative plan.
You said it
There
was
is,
fine. I'm gonna go ahead.
as to there is substantial evidence as to element number two, that another person committed the crime. Ms. McCulley testified that it was her intention to kill Ms. Jennings. She testified as to her reasons at the time as to why she wanted to do that. She testified that that was not a rash or an immediate thing, that that conversation had gone on for some period of time, an extended period of time before the actual date of the killing. The third element is the defendant helped, encouraged, or caused the crime to be committed. There's testimony before the jury as to how Ms. Jennings came to be with Ms. McCulley and Mr. Apodaca. There is, again, the text messages of the encouragement and conversations that they had over an extended 15-hour period of time. And there is testimony,
Don't
although
deny it.
controverted,
I do all this
as
got to be
to
very discouraging.
how
If you thought
the
you
crime
had
was
both.
actually committed. And by that I reference Ms. McCulley's contradictory statements at different interviews as to whether or not Mr. Apodaca actually swung the sword, or simply gave it to her as she testified to. The first two portions of that, the court finds that there's substantial evidence that the defendant helped or encouraged, and then there, to a lesser extent, that he caused the crime to be committed by his actions and his encouragement. The court then turns to 142810, which is the second count, count number 2. The elements for conspiracy under 2810 are the defendant and another person by words or acts agree together to commit. And in this case, the charge is first-degree murder. The court finds that there's substantial evidence before the jury, with all inferences and viewed in the light most favorable to the state, that they conspired to and agreed to commit the offense of first-degree murder. 2, the other person, count number 3, the second element is actually an exclusion. The other person was not a state or federal agent acting in the agent's official capacity at the time. That is not relevant to this case. There's never been testimony or any argument that either Ms. McCulley or Mr. Apodaca were state or federal agents. The second element would be the conspiracy alleged in this count must be separate, distinct, and not constitute part of count number 1. The court finds that it is, that there is substantial evidence before the jury upon which they can
His
reasonably
head is
conclude
in a fight.
that there was the
One versus
communications
the other.
and the intent that occurred prior to Ms. Jennings being present on the 28th and the 29th, and then the conversation as testified to.
Yeah, those don't
the
count.
search made by Mr. Apodaca about possible disposal of the body or how to dispose of the body. And then the third element, that the defendant and the other person intended to commit the offense of first-degree murder. The court finds that there is again substantial evidence before the jury based upon the evidence, the text messages, the statements by Mr. Apodaca during his interview with law enforcement, and the other circumstantial evidence and expert testimony testified to that both the defendant and Ms. McCulley intended to commit the offense of first-degree murder. And then the final count, the final element of count number 2 is that this happened in the state of New Mexico on or about the 28th and 29th day of October 2022. And the court finds that there is substantial evidence before the jury upon which they could reach that conclusion. The motions for directed verdict are denied, and the case will go forward with both count number 1 and count number 2. Is there need for clarification of the court's findings, conclusions, or ruling, Mr. Long?
No, Your Honor, thank you.
Counsel?
Not for defense, Your Honor.
Okay. We've got about 15 minutes, so we're not going to get a lot done. I have a pack, unless they've been changed in between the computer problems today. My administrative assistant did print out the instructions, so I took a cursory review when I walked back at them, but I haven't read them or spell checked them or anything like that. Let's do this.
All right, guys. So they're getting ready to go into their first glance at jury instructions. So we'll let them do that because we're going to have to listen to them anyway. And they're going to have to finish this up tomorrow because they only got 15 minutes before judge is going to be out of there. So what we'll do is we'll go ahead and end for today. We'll come in. It looks like we're starting about 30 minutes later tomorrow. So instead of starting at 7:30 a.m. Pacific Standard Time, we're actually going to be starting at 8 a.m. Pacific Standard Time, which will be 11 a.m. Eastern. So we'll get this recapped, and we'll be back tomorrow morning to see if 1, the defense decides to put on a case. 2, if Isaac changes his mind and decides to testify, because he absolutely has that right, just like he has the right to put on a case. If the defense does put on a case, who are they calling? Right? Who are they calling? And then above all of that, we still have closing arguments. Let's see what everybody does. And then will there be a coup de grace in that rebuttal closing? Or if the defense puts on a case, will there be a rebuttal case by the state? We got a lot going on, but we'll see y'all tomorrow in the morning.